All right, we're going to get started. Thank you so much for joining us today. My name is Anna Yulsman, and I'm a research analyst at the Tishman Environment and Design Center. We are very grateful that you took time out of a very busy climate week to dig into cumulative impacts policy design and the development happening across the US at the state level. Before we get started, I have some quick housekeeping and IT announcements. We are recording this webinar and we will share the recording along with the slide deck after the event. We are also asking that you please remain on mute for the duration of the event. We did keep the Zoom meeting style so that you could take a look at who is joining us, but please stay on mute so that we don't draw attention away from our speakers. If you have any technical issues, please reach out to Mike Harrington in the chat. He's going to be able to assist you. And lastly, please use the chat for any questions that come up as you're listening. There will be a Q&A section toward the end of the program. So to give you a sense of the flow today, we're going to begin with an introduction and some context setting before moving into key findings and insights from a policy landscape review recently conducted by the Tishman Center. And next, we're going to hear from a few advocates in 3 different states who are actively developing cumulative impacts policies at various stages. After that, we will provide a short overview of how to use the new interactive dashboard created by the Tishman Center, and then we'll discuss some of your questions and close out the session from there. Finally, we have a great lineup for you today, which includes both Tishman Center staff as well as some environmental justice advocates. Here are some of the folks you will be hearing from who will be introduced as they start speaking. And now I will pass it over to Tishman Center Director Anna Baptista to get us started.
Thanks, Anna. Welcome, everyone. Good afternoon. Thank you for joining us on this webinar. It's great to see so many folks joining in and interested in cumulative impacts. Yeah, we are in the middle of a very busy climate week here in New York City, but I know we have folks joining us from all over the country who are interested in this topic. So we're happy to have you and hope that we can share this out widely through the recording afterwards as well. I am, as Anna said, the director of the Tishman Center, an associate professor here at the New School University, where the Tishman Center is housed. And our center has been around for 20 years. We primarily work with movement partners around the country to support their work in amplifying and supporting research, policy, and a lot of the convenings that bring multiple sectors with movement partners together. We are pleased to share some of the research that we've been doing for a while now. It's been some years that we have accompanied the development of cumulative impacts policies across many states. And in full disclosure, I am also a member of the New Jersey Environmental Justice Alliance's board and have been active for a long time in my career in the environmental justice movement space in New Jersey and in Newark. And so was privileged to work with leaders there on the environmental justice law that was developed in New Jersey while I was at the center. And so our center was really, indirectly, but also sometimes pulled in some ways to support the development, even in the early stages of the New Jersey EJ law. So we had a unique perspective into that work. And when we were doing that, it became clear that it was useful to have a set of tools and sort of a catalog of policies that were rapidly emerging that could help inform advocates as they were grappling with how to bring forward EJ policies. And so this tool comes out of some of that work. But and you can share more about the development of the tool over the years. But the purpose of today's convening is hopefully to give you a really high-level sense of the key findings of a database that we've put together of policies that primarily are at the state level. There are some at the city and municipal level that are focused specifically on cumulative impacts and permitting. And there's lots of different EJ laws out there. There's even some cumulative impacts tools and mapping tools, but we have focused this database and the research specifically on cumulative impacts policies related to permitting in states. Um, the other thing we're going to share with you are some trends and patterns that we see in both proposed and enacted state CI laws related to permitting, and any, common frameworks, special features, even the potential loopholes or pitfalls that some of these designs, should highlight for us. We have a new database that we are going to showcase for you today. It's a little bit of a coming out party for this database. We've come a long way since long spreadsheets to a little bit nicer, user-friendly database. And more importantly, I think many of these webinars, we have a lot of friends in higher education and academia that are interested in cumulative impacts for a variety of reasons. And we would love to share with those peers of ours some best practices around how do we accompany and best support our EJ leaders that are really driving this work and should be driving this work. So we have some lessons and insights from there as well. So I'd like to now really turn it to my good friend and colleague, Melissa Miles, who's the Executive Director of the New Jersey Environmental Justice Alliance. And Melissa is an amazing advocate. She began her career as a community organizer, living in an EJ community in Newark. That's where I met her. She's doing her work there. She's got an MA in anthropology from the New School, which we're very proud of, as she's an alum. And yet, she has deep roots from her lived experience as an organizer in community. And so she brings a wealth of knowledge and experience in doing this work, and was one of the group of folks that won an award from the governor for her work on the passage of the landmark New Jersey EJ law. So I would love to open us up with some words of wisdom from Melissa, particularly for the EJ groups on the call today. Thank you, Melissa, for joining us.
Thank you for having me, Anna. And yes, shout out to the New School alum on the call. Yeah, and to all the friends and colleagues on the call. So I'm just going to say a few words about why the front lines really have to lead these processes around cumulative impacts policies in states and in municipalities, especially at a moment where so many folks are holding knowledge and expertise on cumulative impacts, and where we see that good aligned partnership can really make or break a process, and where unaligned can be very problematic for the process. And so, I'm really fortunate to have seen this process of the New Jersey EJ law, from being an organizer to being an ED, and really kind of having a bird's eye view. But my colleague Brooke is going to talk more about the realities of what's happening in New Jersey. I'd like to speak from a more generalized sense, both for our frontline partners and for the allies on the call. So, why must the front lines lead? The front lines is a powerful and constantly shifting reality, right? It's a designation that's tied to a specific location and the realities of those locations. It's about living and working, as well as having accountability to the people living and working closest to the problem. And that accountability is absolutely key. This process does not move without that accountability to community. So at a moment where we have many strong intermediaries and a support sector really growing around frontline groups, that support sector at best can be allies and co-conspirators, but we really have to be careful of losing sight of the localized knowledge and impacts. When we lose sight of that localized knowledge, then it can, even a process that is intended to be good can be a hindrance to the long-term self-determination of communities. So, we have to remember that, our support sector ultimately don't have to live with the impacts of the policies and political realities that they may influence, in the course of their work on cumulative impacts. And sometimes that influence can be unknown to people who are not actually on the ground because they're separate from the fabric of the political life that the frontline groups will constantly have to navigate through the process and even after. So the power, as we all know, politics are local, and the power dynamics, that are very unique to a place can easily be misinterpreted. There are those subtle realities, the presence or absence of discrete possibilities that are not always spoken aloud, right? So there exists within communities a fabric of life that is very difficult to translate to the outsider, which is so much of why, EJ, climate justice grows from that fabric, from that soil. And we may see the fruit, it takes the sun and the light and the water, but the realities of that soil are deeply hidden, right? The roots are hidden. So, the expertise that leads to gains in one place may actually inadvertently cause pains in another one. So much, as we know, like certain plants will thrive in some environments and die in others. We have to be attuned, to the alkalinity. We have to be attuned to that soil and the realities of the environment of that place. So, the best partnerships, I think, that are formed with outside technical partners and entities can actually be the glue for diverse local perspectives when it's approached with vulnerability and humility. And I was so fortunate to be part of a process where we had strong technical partners. It actually took the long-term, partnership of more than 5 organizations to get, the New Jersey law from soup to nuts. And when you have an open dialogue, humility, vulnerability, and accountability to the ground, you really have what you need for a strong process. And on the other side, what I would say to the grassroots partners is stay in the driver's seat of your own process, right? It's easy to believe that someone else has what you need, to make the process happen. But, remember who you are and what's come before you, because nothing is new under the sun, right? So every community has some process that's already laid the foundation and the groundwork for a cumulative impacts process. So remember to seek to integrate, that knowledge of what's come before you and who's come before you into the process. Never believe that someone's bringing something new to you because, if you're already there on the ground, chances are you've already seen it, right? And what these partners will help to do is help you to synthesize it and again, be that glue that brings it all together. You also are going to be responsible as being on the ground, filling in those gaps, that policy lag, that time between the time that you envision this cumulative impacts process and the time that it's actually executed can be many years, right? And so it's going to be up to the frontline grassroots groups to fill in the gaps and protect communities while that process is happening and before it's actually implemented. So, to the grassroots groups, your presence is absolutely needed. None of this happens without, your organizational support, your time, your resource. So stay in the driver's seat of that process. And, for our support partners, thank you so much for being allied with us in this. And, I hope that these tools will allow many more communities to begin to envision a deeper set of protections for their communities. Thank you so much.
Thank you so much, Melissa. Thank you for jumping in here and grounding us in the purpose and vision for what we need to actually win cumulative impacts policies that are successful and that make a real difference for communities on the ground. So I'm actually going to turn it over to my colleague and Yukian Lam. Dr. Lam is a senior scientist and the research director here at the Tishman Center. She brings a long history of doing research both in public health, cumulative impacts, and many other areas of work with EJ communities. So I'm very happy to have her share with us the database.
Thank you so much, Anna, and thank you, Melissa, for those really important grounding remarks. On behalf of the research team at the Tishman Center, I am so happy to share with you our newly relaunched database that now focuses on state-level cumulative impacts permitting legislation. And some of these findings that we're going to discuss that emerge from our analysis of what's in the database will be in a forthcoming article in the Journal of Environmental Justice, and we'll be posting that article along with other updates about our work on our cumulative impacts landing page, which you can see linked to the right. So I wanted to start by just giving a little information about what we include in the database, which forms the basis of our analysis. So we focused here on state laws and bills that incorporate a cumulative impacts requirement in environmental permitting. We also include here implementing rules and legislation, rules and regulations for those CI permitting bills and laws. And we've also included any official cumulative impacts mapping tools and methodologies from those states. That helps to contextualize the policymaking. More detailed methods will be in the article that I just mentioned, but just in brief, our data collection was based on looking at state legislative databases, web searches, as well as direct knowledge of legislative initiatives often obtained from direct contact with local advocates. So, as you can see from these figures, one general important finding that emerged from our review of this policy landscape is just the extent to which this is a growing field, particularly over the last 5 years since New Jersey passed its landmark environmental justice and cumulative impacts permitting law. Even between the time that we submitted our article for publication and now, we've seen the number of cumulative impacts bills continue to increase. And to date, we've seen at least 8 states that have codified a cumulative impacts permitting requirement, and at least 14 states have proposed cumulative impacts permitting legislation, sometimes quite detailed. So an interesting feature that looking across a lot of these bills and laws is that many of them employ sort of this common 3-part structure. And this is really what I'm going to be spending the bulk of the presentation on today, just explaining the parts and the nuances in some of the parts of the process. So the first part has entailed the identification of communities that really inform where the cumulative impacts permitting requirement will actually apply. There's different terms used in the bills and laws. Sometimes these are called environmental justice communities or environmental justice areas of concern or overburdened communities. But the basic idea is there's this universe of communities that gets identified, and that's going to help to inform where the permitting requirements get applied. The second part is there's a requirement for some kind of analysis to be conducted for specific permits and facility types arising in or near those communities. What I'll note here is that actually the methods for those analyses tend to not be prescribed in the bill or law. Often this is left for agency rulemaking, but we will share a little bit of details, what we know so far that's coming out about those analyses. And then of course, the third part, the very important part, is the course of action pertaining to the permit that gets triggered depending on the outcome of that analysis. Again, the details vary by legislation, but the essence here is that the specified analysis answers the question of whether or not the permit might get denied, or whether it might get certain conditions, or whether it's allowed to go forward. One thing that's kind of cross-cutting that you see across all 3 parts, of course, is that there are often in the bills and laws provisions related to process, to community participation, to public participation. These will include things like timelines and notice requirements and so forth. And so that kind of is embedded or woven across all 3 parts. Okay, so now I'm going to talk about some of the nuances that are coming up. So on the permits and facilities themselves, what we've seen here is that the cumulative impacts policies in the database cover various permit types, including those for new facilities, expansions of facilities, and renewals. And so most of the policies we found kind of cover all three of those to some extent. Maybe they're not treated the same way, but they are covered. This is obviously important because the renewals kind of get at the legacy of pollution, right? And the new permits get at the exacerbation of pollution over time. The cumulative impacts policies that we analyze also usually describe some kind of universe of facilities, facility types that are covered. And what we've seen here is that common facility types include major source air pollution, generators of a certain capacity, incinerators, sewage, and other waste facilities. With this particular component of the CI policy, there is often room for tailoring, right? As you can imagine, tailoring towards specific facilities that are of concern to the environmental justice communities in a given state. Also relevant to the scope of protection is the identification of communities covered by the CI permitting policy, as I kind of mentioned before. And in this regard, we noticed that many of the policies defined a set of communities based on socio-demographic indicators and thresholds. And this led us, in fact, to actually go down a little bit more detailed analysis of what exactly those definitions look like. And so looking across those laws and bills that defined environmental justice communities in that, using that kind of general approach, we found that many definitions included indicators like household income and people of color population. They included anywhere between 1 to 5 of these indicators, and they set quantitative thresholds for each indicator. And sometimes these thresholds are a set number. For example, 35% or 40% of households are considered low income, something like that. Sometimes they are set in terms of a state average. And another important feature we noticed was if you're thinking about the different indicators in the cases where there's more than one, those indicators can be linked either disjunctively or conjunctively, right? Meaning that does the definition mean that the community has to meet more than one of those indicators, so they're kind of linked by an and, or just one of them, so they're linked by an or. So this actually turns out to be quite important. We took from there the definitions that had this kind of structure, and we did a quantitative analysis where we went to see, in fact, what would be the state population covered by the environmental justice community definition. Again, we have more detailed methods on the sources we used and how we did this actual number crunching in the article that's forthcoming. But what we found here was a really big range. So the population proportion covered under each state's corresponding environmental justice community definition really varied significantly, with the extent of coverage very much influenced by how that definition was constructed and how it was sort of designed. For example, did the communities have to meet only one of the criteria or more than one of the criteria? It also seemed to be influential whether or not those thresholds that I mentioned, those quantitative thresholds, were set, for example, very close to the state average. For example, if the state average of percent people of color is somewhere around 40%, was that threshold set at the 40% or perhaps higher or lower? I just wanted to make a kind of a little bit of a note here that the extent to which the state is covered by this percent of by the EJ community definition is related to the percent of the population that's protected by the cumulative impacts permitting policy, but it's not necessarily a one-to-one kind of correspondence, right? So for example, if the community definition says a certain thing, but then in the policy protection, it's like, well, as long as the permit comes within 2 miles or 3 miles of a defined environmental justice community, you can see how those radii would then broaden the scope of protection. So just note here that there is still aspects of the policy's definition that really matter in terms of what is the ultimate scope of protected communities. Okay. Another really, really important part of The policy has to do with the decision on the permit. So this really gets at the strength of the mandate and the details around the decision-making pathway to be taken by the agency. So on the issue of the strength of the mandate, we're talking here about the difference in statutory language between, for example, may deny the permit versus shall or must deny the permit. And we found that really a necessary but not sufficient condition of a strong policy language is that it obligates the decision maker to deny permits, at least of a certain type, under certain conditions. Now, in some policies, we see that the strength of the decision mandate can actually vary based on whether the permit in question pertains to a new facility or whether or not it's like a renewal or an expansion. So for example, in New Jersey, new permits meeting a certain threshold get an obligatory denial, whereas expansions and renewals meeting that same threshold get conditions applied to them. So that obviously raises an important question of when is something considered a new permit versus a modification. And our colleague Brianna will later talk more about, Brooke will later talk more about that. Many of the bills and laws also have statutory language that describe when the decision mandate is triggered. So that kind of gets at, how much is too much additional pollution such that the permit must be or could be denied. And again, pointing to New Jersey as an example, new permits must be denied if they cause or contribute any amount of additional burden, and there isn't a threshold of amount of contribution that needs to be met. In Minnesota, for example, the statutory language there is substantial adverse impact, and what that means is now being defined in rulemaking. In New York, you see kind of both of these elements combined and important for the standards for when permits result in a mandatory denial, differing between new permits and modifications and renewals. So again, like here you see, as I've shown, the de minimis amount of pollution being the standard for new permits and significant increase being the statutory language for denial of modifications and renewals. Okay, so as with any policy, it's important to consider what are some exceptions and loopholes. And as I mentioned before, that really strong obligatory language like must or shall deny, it's a necessary but not sufficient condition because there can be things like loopholes. So for example, in many laws, we did not the majority, but in some of them, we did see this public interest exception used to change the decision outcome. So permits that would otherwise have an obligatory denial might still be allowed if some kind of public interest exception is met. That is the case of New Jersey's law, as well as in some of the bills proposed in Michigan, I think Georgia, and Washington. In New York, the compelling public interest provision isn't used to directly alter the decision outcome, but it does change the level of review, so to speak, of some of the permits. We've also seen CBAs, short for community benefits agreements, also used in different ways. For example, they could be used, as in the case of Minnesota, as a permit that would otherwise be obligatorily denied could still be approved if the facility owner or operator enters into this CBA. All right, and so now I'm just going to briefly say a few words. So we've talked a bit about this first piece of identifying communities. We've talked about this decision outcome as the last piece, and I've kind of saved this middle part, the CI analysis, for last because, in fact, we actually don't have that many examples of adopted methodologies tied to CI legislation because this is often still being determined in rulemaking. In the case of New Jersey, it actually took like over about 2 years to come up with the rule that would define the analysis for the environmental justice law. New York is actively now in the rulemaking phase to determine that what does that analysis look like. So we don't have a lot of examples. What I want to say here is that folks might have heard of or seen tools like Virus Screen, right? Environmental justice mapping tools, and what they do using kind of this concept of cumulative impacts is they take a bunch of indicators, you crunch the numbers a certain way, and then you come up with a single score called, whatever that score might be called. It's essentially an index score. And then there's a threshold that gets set at least in the case of Cumulative, that kind of designates, okay, this is an area that is disadvantaged or experiencing cumulative impacts burdens. What we found is that although there are a lot of mapping tools out there, a lot of them aren't actually tied to a cumulative impacts permitting policy, and they might not even necessarily be referenced even when there is a state bill or law in the same state. For New Jersey, which is one of the few states that does have a cumulative impacts analysis methodology defined and attached to an environmental justice law, that method actually does not use the single scoring methodology of Cal-EnviroScreen. It uses a separate method that some scholars have called the matrix method or the New Jersey method, where environmental and social stressors are kind of evaluated one by one in a given community against a geographic reference point that is either the state level or the county level. So I think it's a little too early to say right now, which method is going to become more widely adopted. And whether or not you use the first or the second method, we do know that some of the common indicators that have kind of surfaced here are things like environmental indicators, public health impacts, sensitive populations, and socioeconomic factors. The important point really here, though, is that the analysis is key to determining how readily a certain specific course of action, like denying the permit, gets triggered, right? So obviously, we do need to pay attention to the rulemaking that defines the methodology. Okay, and last but not least, I want to talk a bit about the issue of public participation. Our paper actually doesn't really go into a huge amount of detail on public participation provisions. There are these provisions, they often talk of things like public comment periods, notice requirements, and public hearings. These are important elements that we do want to analyze in future work. What is really becoming evident for us is that I think more clarity is really needed around the public input becoming decision determinative. And we've seen here that there are really key intersections between public participation and actual policy determinations, policy decision points. Here's some example questions, right? So for example, can communities self-designate as EJ communities? If so, how? How are existing burdens assessed? How are potential impacts determined? What counts as an impact or burden? Or even how do we know if a facility in fact serves a compelling public interest in the affected community? How are we reaching that decision? So this is definitely an area of ongoing work, and that really hones in on the fact that you can't really isolate public participation as sort of this separate process or procedural issue, right? It really has very, very important tangible material connections. Okay, so basically just a few takeaways before I pass it to the state advocates, right? We've talked about that the devil is really in the details with these policies. So, there's a lot on the decision mandate, potential exemptions, the scope of protection. We've seen at the same time quite a lot of opportunity to align potential CI policy to local priorities. So, while we obviously very glad to see New Jersey inspire this wave of policymaking, we are not saying that you should do, a copy and paste, right? And I think Melissa really brought that home in her comments at what might work for one for another place. Another thing is to really talk about that we found was that there are various mapping tools out there, but we have not at least observed them to be major drivers of policy. The mapping tools that exist do obviously help to show the problem of environmental injustice, but the solution lies, at least in part, in having effective, implemented, strong cumulative impacts policies. And then finally, we've really seen rulemaking as a key to having an effective policy. And that really just hones in on the fact that technical allies, environmental justice advocates, so forth, really need to stay vigilant even after the law is passed to really make sure that the rules, the devil in the details there, serve the purpose of the policy to begin with. All right, so with that, I wanted to actually have some of our state advocates really speak to these intricacies that we're seeing. And I'm going to first turn it over to our good partner and colleague, Brooke Helmick, who is the Director of Policy for the New Jersey Environmental Justice Alliance. In her role there, she's worked to further education, advocacy, and policies that prioritize justice and equity for New Jersey's low-income communities and communities of color. And currently, Brooke has been leading a coalition of folks in New Jersey working on the implementation of this law that you've all now heard a lot about. So Brooke, please take it away.
Thanks so much. Hi, folks. It's really great to be here. Like Yukyan said, my name is Brooke, and I'm the Director of Policy with NJEJA. So a bit about NJEJA, as you've heard from Melissa, we are a 23-year-old organization and the first and still only statewide EJ org in New Jersey. As you heard from Melissa and Dr. Baptista at the top of the call, NJEJA played a very large role in getting the cumulative impacts law passed. And in New Jersey, we call that the EJ law or the environmental justice law. So for our state, over 4.5 million residents reside in what we call overburdened communities. EJ communities, that definition or term might change from state to state, but in New Jersey, that's called overburdened communities. And the law regulates the permit application process, as you heard. So for us, that means there's an extra step that's been added in addition to the state DEP permit process. Any facility that is part of the 8 industries covered under the law, which, for example, could include major sources of air pollution, incinerators, landfills, and scrap metal facilities, have to comply with the law and the rules by writing what we call an environmental justice impact statement, or an EJIS, which I'll refer to throughout my portion of this presentation. And the facilities have to hold a meeting specifically for public comment on EJ impacts, and the facility must respond to all written and verbal public comment in a document which is submitted to the DEP. And the whole process puts the permit clock on hold. So there's time to go through all of this and address EJ concerns, which the DEP does through the EJ decision. And then once the EJ decision has been finalized and the window for facility appeal has passed, the permit clock restarts and the rest of the permit process occurs, including another hearing and the necessary steps outlined. So as you heard in the presentation, what's really critical for communities in these rules is that DEP can deny permit applications for proposed new facilities if it excludes the EJIS or meaningful participation. And if it's a renewal, then there's still opportunity for community members to get involved, discuss public health impacts and challenges of living next to a polluting facility. And that could be things like sounds, smells, traffic, things that may be mentioned but are not particularly spotlighted in the EJIS. And it's an opportunity for DEP to place conditions on the facility like you heard throughout the presentation. And so part of our advocacy has been calling for conditions which would reduce the total pollution burden of the facility, reduce, kind of getting back to that terminology, the cumulative impact of those facilities. And so, to get a little bit into some of the sticking points, there have been questions on provisions of the conditions, the specific language of the law and the rules. And what I'll drop in the chat in a little bit is 2 letters which we have sent to the DEP. So far we've had 2 decisions issued under the rules. The first is for a facility that processes hazardous waste, and the second is for a facility that generates glass for medical processes. So one of the sticking points in the first decision was whether or not the permit itself is actually a new permit or a renewal. And this comes down to the definition of new facility and change in use. So the facility qualified themselves as a renewal, said that they were modifying and expanding. And the EJ law in New Jersey defines a new facility to include, quote, a change in use of an existing facility. And to break that down further, change in use is defined as, quote, a change in the type of operation of an existing facility that increases the facility's contribution to any environmental and public health stressor in an overburdened community, such as a change to waste processed or stored. So in this particular case, the facility was applying as a modification, as I said, and in both the environmental justice impact statement and the permit modification application, they said that the proposed mixed pit, the new infrastructure they were adding, would be a new treatment method that changed to waste processed or stored. And they're adding this pit because they need new infrastructure to process the new type of waste they're accepting. And so from our vantage point, using new treatment methods and storing and handling new types of waste in a, quote, newly built infrastructure at the facility is not a modification. It would constitute a new portion of the facility and change the permit modification process. Of course, that's just some of the weeds of the first letter, and you can definitely dive in more depth into some of our other thoughts, but for the sake of time, I'm going to touch on actually the second permit, which we wrote a letter to DEP for Corning Pharmaceutical Glass, which, as I said, is a glass manufacturer for medical equipment. And something that's a little bit different is that it's much clearer that this is a permit renewal in the strict sense of the law. And one of the key points of conversation that came out is this question of measurement of emissions and what's called an LICT analysis, which is referred to as a localized impact control technology, which Corning applied only to a specific part of their facility they call their batch house modernization. And the permit renewal applies to the batch house modernization project. And so one argument here has been that LICT analysis should be applied to the entire facility, not just the modified emissions units. And like I said, in the case of Corning, that's their batch house. And so this comes back to the specific nuance of the EJ rules, which say that for an expansion of an existing major source facility, the applicant shall document their LICT technology for the source. And the sort of technical policy question comes down to a definition of the word source and how we interpret that. And so we argue that the source word applies to the entire facility, as the environmental justice rules repeatedly refer to major source facilities as shorthand source. However, the facility interprets the word source to specifically their batch house modernization. And so I feel like I could go on much, much longer. There's so much nuance to all these permits, and I just touched on two of them. But I think that really underscores some of our thoughts on how specific words can take on an entire world of meaning and how communities get involved in interpreting and commenting and what that sort of ongoing dialogue looks like between advocates in the facility as this process moves along. And like I said, I'll drop the letters in the chat for folks who are interested in getting more in the weeds on some of these technical issues.
Thanks so much, Brooke. And let me turn it now to Brianna Carvajal, who is the State Legislative Manager at We Act for Environmental Justice. Brianna is responsible for working directly with state legislators and agencies to build programs and policies that advance environmental justice for the Northern Manhattan community and other EJ communities across New York. Thank you, Brianna.
Thanks so much, Yukian. And thanks, Brooke, for giving us a comprehensive overview of those permits in a short amount of time. I will try to do the same in our 5 to 7 minutes. And I'm excited to talk to you all today about our progress in New York State and what we've been up to in terms of trying to right now work through the regulatory process for the environmental justice citing law. We Act for Environmental Justice began advocating for cumulative impacts, I believe in early 2020s. And we were interested in this piece of legislation because we wanted to make sure that the overwhelming amount of facilities that were located in Northern Manhattan and our close neighbors in the Bronx were beginning to see more regulations in terms of the pollution and the cumulative impact effect of pollution from these different sources in our environmental justice communities, or as defined by New York State, or disadvantaged communities. And so what the intention of the cumulative impacts law is in New York State is, like Brooke and Yukian mentioned, to ratchet down pollution burden in disadvantaged communities across the state. And some of the ways that it does that in our New York law, there are quite a bit of different provisions of this law, but I'll just review some of the top few in time's sake. For new facilities, DEC shall not issue an applicable permit for a new project if it determines that the project will cause or contribute more than a de minimis amount of pollution to a disproportionate pollution burden in the disadvantaged community. Now, for modification or renewals of an applicable permit, DEC shall not issue an applicable permit if it determines the issuance would significantly increase the existing disproportionate pollution burden on the disadvantaged community. So in New York, we have these two different standards of de minimis and significant increase. And these definitions came about in the New York chapter amendment process. Here in New York, we have a process that's called chapter amendments. And that's when, after both houses of our legislature, the Senate and the Assembly, have come to a negotiation process for the legislation, that gets sent to the governor's desk, and the governor has a chance to make edits that more or less are what would it take for her to sign the bill into law. And in this administration, under the Hochul administration, for major pieces of legislation, I think she's edited about 1 in every 7 pieces of legislation that come across her desk. And for us here in New York, there were quite a number of amendments that were made in the final hour of the legislation that resulted in what it looks like today. And I will give a high-level overview of some of those changes and a bit of what those lessons that we learned here in New York. One big one was touched on disproportionate pollution burden. And what that means. That definition is to be defined, as is de minimis and significant increase. So like Yukian mentioned earlier, the devil is in the details when it comes to these cumulative impact policies. But what we had in addition to disproportionate was inequitable. The language originally used to read disproportionate or inequitable pollution burden. We're finding challenging with disproportionate is it's a statistical measure requiring a statistical analysis, and that's challenging to find more or less the perfect language or perfect analysis for defining what is disproportionate. If we had inequitable, that might make it a little bit easier, it might make it a little more challenging, but that was one of the major changes that was made. The other ones that were made, and I'm trying to be quick with this, but I, again, could talk about this for hours, was the existing burden report itself in terms of it being prescriptive. We had quite a bit of what should be in the existing burden report in the existing language, particularly listing particular burdens. Now it's a little bit more general to say relevant baseline data on existing burdens. That is to be determined as well in the regulatory process. And 2 more things before I wrap up here is within our New York law, there is a requirement, there is a portion of it that says the department may not elect to require an existing burden report if the permit would serve an essential environmental health or safety need of the disadvantaged community. And what that means, again, is to be left up in the regulatory process, but we don't want that to mean jobs as a potential benefit. And we want to make sure the community that's affected by pollution is making that determination for themselves. That process for determination is also to be defined. Last but not least, far from least, public participation. The one big difference between New York laws and New Jersey's is public participation and the requirements for where the community weighs in and how. In New York, it was initially a decision in which we were going to try to pass public participation legislation in conjunction with cumulative impacts law. And we've been finding that a bit tricky. And so if I were to do this again, I would want there to be stronger public participation provisions. Right now, we're trying to get stronger provisions in the regulatory process. But if you're starting out and you're wanting to do something similar, definitely strong provisions up front in your original language is key. And one thing I'll do to wrap up is we act as leading community engagement sessions across the state. We are going to different communities, explaining what this law would mean for them and how they might be able to use it. And we will be releasing our comments and processes for how you can be engaged if you or anyone else would like to be involved in cumulative impacts legislation in New York State. I believe Yuken will be sharing our information at the end of the presentation. Thank you.
Thank you so much, Brianna. Okay, and we are collecting your questions, so keep them coming. I see folks conversing with one another. That is great. Let me pass it now to Esther Min, who serves as the Director of Community Innovation, Evaluation, and Learning, supporting evidence-based and data-driven work across Front and Center, which is a statewide coalition of frontline community organizations in Washington state. She brings experience developing community-directed research tools and facilitating community, governmental, and academic partnerships. Esther, please.
Hello, everybody. So I'll be speaking specifically around CURB Pollution Act in Washington State, or Cumulative Risk Burden Pollution Act, if you want to say the whole thing. I will say for our coalition, we launched about 10 years ago as frontline community organizations to create our own space because there wasn't a seat at the decision-making table for frontline communities when it came to environmental justice and decision-making at the state level. And so now we're celebrating our 10-year anniversary this year. And I will say, that we are at a very different stage than New York or New Jersey, where we actually don't have a policy that has passed yet in Washington state. So the journey continues as every year and every social political landscape keeps changing. Now, in Washington state, we do have a very solid and good backbone for environmental justice work, namely the Healthy Environment to All Act that was passed in 2021 that requires 7 different state agencies to incorporate environmental justice into strategic planning, decision-making, and in budget. And we also have a Washington State Environmental Health Disparities Map, which is our version of a cumulative impacts tool that does put communities into deciles for identifying overburdened communities and vulnerable populations within Washington State. So similar to the other EJ screening tools that people talked about earlier, we do actually assign numbers, and there's actually a relative ranking of groups. So it's not a matrix approach or anything. But it really was created to ultimately communicate what these cumulative impacts are in Washington state communities to decision makers and others, because it was so much easier to do that in a map that helped with the understanding. And with the current laws, community really felt like HEAL is a great backbone, but it doesn't quite get around to addressing. So it's just the start, but not the end, to all the disproportionate impacts and the cumulative health risk burden that is happening in our communities. And so CURB Pollution Act kind of builds on that, where we're really thinking about incorporating environmental justice concerns in state policymaking and actually now getting that into action by considering cumulative impacts. So to talk about kind of the sticking points of some of where we're at right now, I did want to talk about kind of the origin story for our state. The whole basis and the foundation for the CURB Act actually started within our coalition, localized knowledge in frontline communities, and many different working groups and conversations where we started with, how do we know where the pollution is, and how do we stop the pollution, all sources of pollution that continues to happen and in some communities worsen over time. We went to kind of the root cause tree diagram. We really thought about what are the realities we see in community, what are the expertise we have, and what are the drivers of the harms and the symptoms that we are actually seeing. And with that, we wanted to think about a way to learn from the prior work that New Jersey and other states had done. And so with the goal to prevent and reduce and eliminate all pollutants, we actually went to our academic partners and technical allies at University of Washington School of Law to help us research into and build a model policy with us. And that's when we looked at other states. We thought about, okay, how do you stop these explicit pollutions from happening or continuing to happen in the state of Washington, considering cumulative impacts? How do we consider community participation in the process for transparency and accountability for the industries, for government? And how do we give more power to the state of Washington to be able to say, you know what, this is going to cause more harm. We should stop it. We should say no. And they have the authority to say no. And so thanks to the many of the partners here that are on the call today, we learned a lot from the lessons learned. And we really struggled with one of the aspects of like, how do we now put all the lessons learned and the principles and the spirit of these cumulative impact policies in the context of Washington State. Knowing that we have a good cumulative impacts mapping tool, we can start to identify some of the communities, knowing that I can't identify all the communities because of data limitations. How do we identify them and think about the air, the water, the waste, and other pollutions and the permitting decisions that's related to it? How do we think of a lead agency that can conduct or dictate somebody to conduct an environmental justice impact statement? And what are those opportunities for transparency and community participation? One of the sticking points during that model policy was, well, how much pollution is too much? How do we think about the stressors, knowing that we have a good backbone already with the map, and there are so many more burdens that are yet available as a data set, or maybe data is available but not modeled yet, or it's collected but in all sorts of different places. And then once we had the model policy, we now are at the really sticky point of the realities of the sausage making of policymaking. And so how do we now move forward with this ideal model policy with research and analysis done by our technical partners? And how do we think about that and apply that with the realities of existing processes within Washington State? We have what's called the SEPA process that requires an environmental impact statement. So how does this environmental justice impact assessment relate to that? How do we think about the solutions ultimately envisioned by our community that we've developed an allyship with as a model policy with academics, and now really thinking about it with our government and decision makers that are allies, and thinking about how do we move this forward? And so our Curb Pollution Act is still in the works. We celebrated the longest, lowest death in state policy this year as an environmental justice bill in state legislature. So the last one standing, which was a celebratory point. And how do you really think about kind of the best practices of keeping the spirit of that model policy alive that was truly envisioned with frontline communities and good solid research? And how do we now make that a reality, whether it's piecemealing, however that is done, knowing that our social political context keeps changing both nationally, but within the state as well. And so we are now embarking on that journey. I'll pass back to you.
Thank you so much, Esther. Okay. Like I said, keep the questions coming, and I'm noticing that there are probably way more questions than we'll be able to address. We are valiantly trying to answer some of them in the chat, but we'll get to as many as we can. And we are going to share with you an email address where you can later send us any feedback, additional questions. So we will definitely see this as the start of a conversation. Okay, so now I'm going to actually pass the mic over to my colleague on our research team here at the Tishman Center, an analyst, Madeline Killow, who is going to share this database tool with you. Madeline.
Perfect. Thank you, Yuken. Hi, everyone. I will be presenting the Tishman Center's new interactive dashboard, and I will share my screen now to walk you all through the dashboard in real time. Okay. Can you all see? Okay. All right, beautiful. So this is the Tishman Center's webpage for cumulative impacts. If you scroll down, you will find our interactive dashboard called the State Cumulative Impacts Permitting Policies Database 2.0. So before I go into the details of navigating the dashboard, I wanted to provide some context on the high-level information that can be found here. So this database compiles information on the incorporation of cumulative impacts, or CI, requirements in U.S. state environmental permitting frameworks. The database includes both enacted and proposed legislation, government agency rules and regulations, as well as select state methodologies and tools. For each entry, the database provides information on the definition of cumulative impacts, relevant indicators and thresholds, as well as the primary purpose and scope of the instrument. Where possible, links to source legislation, agency documentation, and official websites are also included, which I will show briefly. So when using the dashboard, users will first go to this interactive map. Right now, you can see Washington is selected, but if you hover over any of the blue states, you will see that all of the relevant cumulative impacts related policies, rules, or tools methodologies are listed associated with the state. So for Washington, we have the environmental health disparities map, the mapping tool, as well as the policy that Esther was just talking about, the CURB Act. So we are actually going to use New Jersey as an example for this presentation and walkthrough, which actually has three related, instruments. It has the EJ map, their environmental justice mapping assessment and protection tool, as well as their past EJ law and the associated environmental justice rule. So when you select a state, you will then go down to this drop-down menu where you'll be able to choose the associated instrument that you would like to learn more about. So again, for these purposes, we're going to walk through their environmental justice rule. When you select the instrument that you're curious about, you'll see information populate on the dashboard. Right below the drop-down menu, there is a small short summary box. This includes information such as the short title of the policy, rule, or tool. So in this case, the short code associated with the rule, the instrument type, a rule or regulation in this case, its status, which is currently adopted, the issuing body, so the New Jersey Department of Environmental Protection, the year it was introduced or released, so 2022, and then recent activity. So in this case, that would be April 17th of 2023, where this rule was adopted. Then if you go up to this box on the top right, you can see the full title, so the short code plus the name, which is the Environmental Justice Rule. These titles are also hyperlinked, so if you click on this box, it will bring you to the full text, in this case, of the rule. If you were looking at a mapping tool on the dashboard, it would bring you to the website where that mapping tool is hosted, likely on the government or agency website. And then this main box here will show the most detail about the instrument that you've selected and can be filtered using these buttons down the middle. So it will automatically start with the purpose and scope of application for, in this case, the rule we've selected. This information includes a brief overview of what the rule covers and the purpose, as well as permit application requirements, public participation standards, permit review processes, and any additional provisions. You can also look at, we have filters for, or buttons for applicable facilities. So to show, for this rule, the applicable facilities listed include things like major sources of air pollution, resource recovery facilities, etc. You can also look at the definition of environmental justice or overburdened communities, if applicable, and defined in the instrument. So in this case, the New Jersey rule defines overburdened community through these census qualifications. We also have information on the definition of cumulative impacts. You can see here it's listed as not specified. This is because this box will be filled if the policy, rule, or tool you're looking at provides a qualitative description of cumulative impacts, which not all do. So if that information is not explicitly listed in the instrument, you'll see not specified here. You can also see the methodology or the calculation used for assessing cumulative impacts, which in this case for the New Jersey rule, they apply a two-step comparison methodology to determine whether an overburdened community block group is subject to adverse cumulative stressors compared to the geographic point of comparison. If you want to dive more into that methodology, again, more detailed information is below. You can see the indicators used in the calculation for CI. So in this case, the New Jersey Department of Environmental Protection identified 26 environmental and public health stressors. You can see the category groups and specific lists here. We also have thresholds for determining the existence of cumulative impacts. So again, that sort of trigger point of when it's decided that CI applies to a certain area. As well as any additional notes that the Tishman team, found relevant and context for the instrument, as well as other links. So in this case, we have listed the New Jersey Department of Environmental Protection published a FAQ doc on the rule, which we linked here as well. Importantly, this database is not static. It is updated twice a year in January and August, which aligns with most state legislative calendars. However, since policies, rules, and mapping tools can undergo changes between our biannual updates, we recommend that users consult the relevant state legislative or agency website for the most recent status of a specific bill, tool, or rule. And again, just on a high level, this database is designed as a reference tool for researchers, policymakers, and advocates and EJ organizations to explore how different states are defining and addressing cumulative impacts, specifically in permitting, as mentioned. You can use it to compare legislative and regulatory approaches, identify emerging policy trends, and access links to original sources and texts for deeper review. This database is not meant to be an exhaustive catalog, but rather a snapshot of representative policies and tools to guide analysis and advocacy. So again, this will be updated biannually to hopefully reflect the growth of CI policies, rules, and tools across the US moving forward. And we hope it is a helpful resource for you all as well. Thank you so much. And I think now we can open it up to Q&A. So I will pass it back to Yuken.
Yeah, thanks everybody. I'm gonna try to maybe bucket a few of these questions together. So we are hearing some questions on the mapping. I'm seeing a bunch of questions on public participation, and there's some questions also about NEPA intersections with NEPA, a question about environmental process streamlining. So maybe I'm gonna try to go in that order. So let me start a little bit on the mapping questions. We got a question from the audience, what would make mapping tools stronger, or are there different tools that would serve our purposes better? And I was thinking, maybe Anna, would you like to speak to that? Because I know you've studied the mapping tools too for very, very many years.
Yeah, this is a big question, so I'm not sure I'm going to fully answer it. And I also welcome input from the other speakers on the panel and thoughts on this, because I have multiple minds. One person's strong mapping tool is another person's not so strong mapping tool. Because I think how you define strong, I think from a community standpoint, you want the maps or the tool to reflect as close as possible the reality, right, of the burdens. That doesn't necessarily mean the perfect map with every bit of data that ever existed, because oftentimes the attempt to make a very comprehensive mapping tool can get in the way. The perfect can get in the way of the reality, right? Which is the end goal is not to have a perfect map. The end goal is to have a tool that can be a decision-making tool. It's good enough, it reflects enough of the reality of the burdens that are real burdens to the communities that we're talking about, that then can be used as a decision-making tool. So it has to be both legally defensible and hold up through a rulemaking and in law purposes, right? But it has to be robust enough to reflect the reality on the ground of burdens. So it has to have multiple elements to it, I think, to make it a strong and usable tool. And and there's a tension there. There is a tension because a lot of times people are like, well, we don't have enough grassroots data, community, science, or more of the micro data that just doesn't exist at a state level or sometimes misses things. So it's really important that whatever tool is used is ground truth with EJ advocates. So like in California, that Cal Enviro screen was developed first by communities. Actually, there was a lot of community input in developing mapping, and that really reflected burdens on the ground. And eventually the Cal EPA developed a Cal Enviro screen that was informed by that. So as much as possible, if they can be ground truth with communities, that's great. But I would warn against going down the rabbit hole of cumulative impacts mapping into perpetuity, which, sometimes can happen with agencies where they're like, well, we don't have enough health data, so we're just not going to include anything, or we're not going to finish or be able to use this as a tool in policy because our tool is not perfect. And so they use it as an excuse to forestall decision making. So that's just my 2 cents on the and I know there's some back and forth in the chat about like matrix versus single score. I'll tell you that in New Jersey, we were like, let's use the California Enviro screen method because it's it's tested. It's been around for a really long time. It's empirically really, well documented. And in New Jersey, the New Jersey regulators, we worked really closely with them, and they proposed the single score method, which we came to really appreciate as well as an alternative. One, for its simplicity, and it was, it actually is not that simple to explain, but it works, right? It works for us, so it's fit to purpose for us. So it really depends on your context, like what's the tool that makes sense for your state. Wouldn't say one is maybe better than the other. It also depends on the kind of data indicators you have as well. How good of are the data indicators? How big of a difference do you have between urban and rural areas? Are you capturing all that? So, but other people may have strong opinions on like they really favor one method over the other.
Thanks, Anna. Yeah, I definitely want to emphasize that point that sometimes like getting that perfect data has been used for an excuse for inaction for a really long time, right? And also we've even seen some cumulative impact assessment methodologies get so specific into like, oh, we have to actually calculate what is that synergistic effect or that interactive effect. And it's like, actually the interactive effect, like the fact that there are synergistic effects, that's a statement of the problem. Don't let the problem become the supposed solution. We know that there is the problem. The solution is actually preventing additional burden, right? So that's a really important point that we did want to share. Okay, we have a New York specific question for Brianna. What specific public participation requirements might you want to add to the New York law if you could do it again? And I will also tag Brooke maybe for some insight into the public comment question. For example, we have a question here about do the regulatory agencies issuing the permit also have robust education or guidance or publications about how they use public comments? And if you have any general insight into what makes a good public comment. So I'll go to Brianna first and then.
Yeah, thanks for asking that question. We had written a letter to DEC around this time last year, outlining what we would believe would be some best practices for public participation in this process. After this presentation, we'll have those letters that we've written in the past available on our website, and we can share that with you again, share that with you all. But I'll go over some of the top recommendations that we provided. Firstly, that the applicant for the permit hold public hearings to ensure the public can comment on aspects of the process, such as the screen for whether the project impacts a DAC, whether or not disproportionate burden report should be required, and design measures to reduce disproportionate burdens, that there be at least 3 public sessions held with a mixture of in-person and hybrid on times of the day that people are able to attend, and that all those meetings should be reported and put on a website publicly available for viewing online. That those public notices about these meetings should be written in at least top 5 languages, spoken in the community, that appropriate outreach efforts be made, and so many more ways that this could be a way, ways that we can make sure we're capturing good public comments, good engagements. And I think one other really important thing I'll mention is making sure there is a process by which the applicant and the agency are required to respond to public comment questions and concerns, and making those comments available for the public to see. And so those are just some of the ways. And again, that was a lot of information, so that could be available online on our website. And a lot of what I just suggested, I know some of it is in practice in New Jersey, so I'll pass it to Brooke.
Yeah, thanks. So I can answer maybe a few different questions in one if I can. So in terms of how they use the public comments, this has been a through line in both of the letters that we've submitted with our colleagues, in that we do think there could be some more transparency in that process and how they interpret some of these sticking point issues that we have mentioned. But I will say, which is not quite an answer to the question, but could be helpful, is that the department has put out guidance to facilities on how to do meaningful public participation. So that includes things like posting in the community, including in including in languages that are non-English, but are spoken within the community. That includes things like doing outreach plans and connecting with local groups. There have only been 2 decisions so far, and we have 2 more hearings coming up in October, so there's certainly room to grow. And then to kind of answer the secondary part of that question on what makes a good public comment, I think, starting with just like who you are, what your vested interest is. Are you representing what institution? Where are you coming from? Where are you based out of? And then there are, I think, maybe 4 key points that I would say are worth considering. This is by no means exhaustive. And I think like something that Melissa had said at the top of the call, like the points you make in your public comment should be specific to the community in which you're speaking from. So things that are applicable in New Jersey may not necessarily be applicable in California or in Washington or wherever you're joining this call from. But first, I would say is on the point of monitoring, transparency, and data tracking, we often call for continuous emissions monitoring. In our perspective, stack testing isn't as strong of a requirement as continuous emissions monitoring, and we also call for that continuous emission, said that 3 times now, but we call for that data to be publicly available and accessible to anybody to use, whether you're a community scientist or an academic or what have you. Something else we think about are areas of the facility where technology could be electrified instead of using gas. In both public comments, we called for electrified vehicles, and this of course needs to be done in tandem with a just transition so that we aren't burning fossil fuels to produce the electricity that these fleets run on. The other thing I would say is to check the permit for areas in which the equipment they're using is old. There may be better technology and or control technology that we need to be examining. In our second letter, we talk a little bit about electrified boilers as an opportunity to reduce local emissions. And then also you may want to consider taking a look at emissions limits in different operating scenarios, such as startup and shutdown. Of course, there's much, much more that I think I could say, but those are some of the things that we tend to think about in a public comment.
Thank you so much. Okay, I think maybe we have time for one more question, and I think we've also really tried to emphasize, and you heard from Melissa about like communities being there holding down the fort as these processes take a long time. There's a lot of political organizing that's happening, building power, support, etc. So I was kind of wondering, maybe this is for anybody, I don't know, Esther, if you want to start, but what, in terms of working on this policy in your state, have you found any unexpected allies or any unexpected kind of opposition? Have you kind of grappled with that? And then after that, we will go to close. So let's hear from anyone. Esther, maybe if you want to start with this, I'll pass it to you.
Yeah, and this might not come as a surprise to many people, but and I see in the chat too, that kind of like false narrative of like economy versus environment, has definitely come up a lot. And like, what is this going to do and how is it going to impact jobs? And so it's always a point that we, beyond just curb pollution act, we're always trying to get ahead and really talking about like, it doesn't have to be one or the other, there could be both. And so really kind of trying to draw out the true narratives and really the voices from the front lines, because it's not just a made up kind of philosophical thing, but really like there's a lot of data and examples to show that, this transition is important to us all. And so we've really been working on that just as a coalition too, to talk from kind of what it really means on the ground and the impact, so it doesn't sound too fluffy where people can easily kind of get tripped up on that kind of false narrative.
Thank you. Brooke, anything to share on this end? As you talked a little bit about the opposition.
Yeah, I think Chris, my colleague Chris, put something in the chat that really captures that. I think it's about making sure that you are able to talk about the importance of centering community, and that these laws are not designed to like bog anything down, but to protect people. This is a matter of public health. And I think also, I wanted to just touch on something that I had put in the chat to another question, which is that the EJ law in New Jersey just adds a step. It doesn't allow folks to like bypass the permitting process. So if you're a major source facility that you are not subject to the EJ law, you still have to go through the general permitting process through the DEP. So the EJ law is designed to add a layer of protection, not necessarily create any sort of like loopholes or anything like that.
Thank you so much. And Brianna, any wisdom to share with the group about these fights that are happening, throughout the bill being signed, passed, all of that, all the stuff through the rulemaking? Anything to share?
Yeah, I think these conversations and aligning yourself with allies and folks that have done this work is of utmost importance. We definitely did not pass the cumulative impacts policy alone. We're definitely not working in trying to engage in the regulatory process alone either. We have tapped numerous of our colleagues and professionals and academics in sciences and in law. We've also really been engaged in a dialogue with our agency, and I recommend that other folks do that as well, is regularly be in contact and always have a vision available for what you want to see. Again, I think going back to what we heard earlier at the presentation, that the frontline communities need to be driving this, and the more clear vision, the more specificity you're able to provide, the better the outcome will be in the long run. So those are just some high level takeaways I wanted to share.
Yeah, thank you so much. I'm going to turn it back to Anna to close this out.
Yes, I want to thank Yukian and Madeline and Anna, all those staff who worked on this tool and the presentation. It's a lot of hard work, and I think it's something we're committed to continuing to update and share out with all of you. So thank you to the staff. Thank you to our speakers. It's really important to remember the people that are doing the hard work for years, sometimes decades. The communities on the ground that pour their blood, sweat, and tears into seeing these imperfect tools passed. And that's the reality. Like, cumulative impacts and permitting is just one tool in a toolbox where we need we need a lot more bills and laws to help undo the legacy of environmental injustice. But cumulative impacts is an important part of that puzzle. And so kudos to all of you for keeping up the good fight to try to get us closer to that reality. So just a few things in closing. I hope that this was informative for all of you. I'm sorry if we didn't get to all of your questions, but you can always follow up with us via email so that we can have more of a conversation in depth for any specific questions that we weren't able to get to today. We hope that we will be able to continue to have these conversations that are led by communities and technical allies in a supporting role. And I know that we will have many more opportunities to do that with some of our friends. I see, Marian Engelman Lotto and Charles Lee and Sheila Foster and many of the other folks who've been working alongside EJ advocates on cumulative impacts. So we will continue to look for spaces and opportunities to be available to all of you. And of course, the Tishman Center stands ready to also work with you if there's anything we can do or connect you to others who may be able to help you, whether that's technical or legal or otherwise. We are going to share the recording and the slides with all of you after this session. And we will also be sharing the cumulative impacts article that is going to be published forthcoming in the Environmental Justice Journal. So we'll send that out to all of you and also post it on our website. Our database is actively being updated. So, you can always check back into the database for updates regularly. And if you yourselves have any updates, these tools are dynamic and changing. So you may have things that you're like, oh, that's not right, or this is missing. So please feel free to share that with us if there are things you want to point out or highlight that maybe we have a blind spot on in the tool. We also hope that we can, like I said, we were going to share the slides in the recording, and we invite you to visit the website where we'll be keeping up to date on ongoing issues pertaining to CI policy, because as you all know, like, it feels like, there's policies being proposed all the time. We haven't captured all of those. Sometimes, bills pop up in the legislature we didn't even know anything about, and we just hear it from advocates who let us know. So if you hear about CI bills coming up, please do let us know, and we'll be sure to add them to the database. And that's it for now, but I hope this isn't the last time we have an opportunity to be together and hopefully share more about cumulative impacts with all of you. So thank you all. Hope to hear from you soon. Take care.